Technical Research and Policy at Spence & Partners. And I have the relatively easy job today of just hosting the event. I'm not one of the speakers today, and I will get on to the speakers and the agenda momentarily. But just before I do, a little bit of housekeeping. So hopefully this is the familiar Teams platform that we've used before, which means that the only people you will see and hear are myself and the people joining me today to present. But as always, engagement is possible and is very, very much encouraged. And hopefully in the top right hand side of your screen, you'll see an icon with a little question mark, which is the Q&A box. And please feel free to use it at any time during the event. I will moderate the Q&A box, and I will try to get the right speaker to answer the right question at the opportune Q&As at the end of each session, and there should be a bit of time right at the end of the webinar for anything that has not yet already been answered. So then, turning to today's agenda, as with other FI webinars, we have a bit of a mixed bag. First up today is our own Martin Purvis, who is looking at pension scams. Very topical for a number of reasons, not least a couple of developments which have just happened this month, which I'm sure Martin will be talking to. Then Martin will pass over to Paul Ashcroft and Justin McGilloway from Wedlake Bell. They are very, very welcome to join us today to do our external talk, looking at the subject of equalisation law. So not just GMP equalisation, but wider equality issues too. The next talk after Paul and Justin is getting a bit more specific and looking directly at addressing inequalities arising from guaranteed minimum pensions. And for that one, we are back to someone from the 3173 family of companies, our own Carol Sidebottom from Dalriada. So, as I say, a mix of topics, all very, very relevant and all very, very much hot topics at the moment. So I will not eat into the session any further and will now pass over to Martin to talk about pension scam and scandals. Martin.
Yep, thanks, John. Good morning, everyone. As John has said, I am Martin Purvis from Dalriada. I have been at Dalriada and sister companies for just around 10 years, and quite a few of those years have been working on what's known as pension scams or pensions liberation models. Dalriada, as a way of background, is one of a small number of companies which can take TPR emergency appointments, which are essentially sometimes the worst of the worst in terms of pension schemes which have been targeted by scammers or inappropriate investments. So we just flick on to the first slide, maybe, please, Kaz. Yeah, at a very, very purest point, pensions liberation is essentially where a member can access their benefits before their minimum age allowed under legislation. At the moment, that's 55 years of age, but that will increase in due course. The term pensions liberation fraud was added to the phrase as time went on, and essentially relates to where members have been deliberately missold, as opposed to when they maybe perhaps openly and willingly moved into such arrangements, and also where members have been deliberately misled, in particular about the tax consequences involved in potential liberation models. Pensions is a complicated subject. To the non-pensions educated person on the street, tax consequences for transferring a pension fund or for accessing their own money is completely alien, and unfortunately many people in the past have targeted the public aware that this knowledge wouldn't be out there, and indeed arguably the knowledge wasn't within the pensions industry, who in many cases has been slightly slow to react to potential scams which have now been ongoing for a number of years. So at a high level, historically what we would have seen probably around 10 years ago is an attempt by perpetrators to come up with arguably genuine attempts to breach pensions legislation or to circumvent tax rules, to essentially find loopholes and clever ways of giving people what they want, which at many times is access to their pension savings early. What we have found in recent years is that's been moved away from, often as a result of, I suppose, the potential models being tested and proving to be unfit or inappropriate. What we found in more recent years is that there's been a shift towards channeling money into questionable investments, and from that questionable investment you may find a payment drops out the back to a member. So essentially they've tried to add another layer of documentation over any payments to members, because all of the work to date and all of the cases that have been tested to date through ombudsman or through the regulator or through the courts have proved that there's actually, and there shouldn't be, a way in which members can access their benefits early, albeit apart from reasonable circumstances where somebody might have ill health, early retirement. On to the next slide, please, Kaz. Yeah, a little bit about the size of the problem. And these figures are, I suspect, a little bit outdated, but I also suspect very, very approximate. It's probably very difficult to judge how much has been lost to potential scams within the UK. How exactly would you ever determine that? What we can say from Dalriada's experience internally is that we have been appointed to over 100 scam arrangements or questionable arrangements, and the transfers going into those schemes probably comes in the region of around 270 million. So that's just the cases which Dalriada has, albeit I understand that Dalriada is probably one of the leaders in the general industry for doing this type of work. But that's only, as I say, the cases which we found. So how many cases are there out there which haven't been found and which a professional trustee hasn't been appointed to? So if we have 270 million and you put, you multiply that out, even if we were getting 1 in 4 cases, and even if 1 in 4 cases was becoming a priority for the regulator and they were able to find all of these cases, you could easily be looking at £1 billion worth of funds transferred into these possible schemes. Probably important to note at the moment is that, as a lot of you will, I suspect, be aware, scammers often tend to target people in financial hardship. There are various means of doing that. One would be cold calling, albeit I appreciate that cold calling is now technically not supposed to be done within the pensions industry. What we've seen in the past is scammers have deliberately targeted people that were perhaps trying to pay their mortgage as the economy goes through its usual cycle and people fall into financial hardship. The reality is, as much as it is inappropriate to do, if you were an individual of the public and the choice was between accessing your benefits early, which you maybe have a few reservations about, or indeed paying your mortgage and supporting your family, the answer is often quite clear to many members of the public, and that's one of the things which in the past scammers have preyed on. Also, there's the fact that pension still remains a very confusing subject, I believe, to the general public. We are an industry which loves jargon and pensions terminology, and trying to communicate in the most simplest ways to the public has at times been difficult, and is something which the industry is improving on, but arguably there's still scope for us to do better. Next slide, please, Kaz. Yeah, so what has been the industry reaction? As John alluded to, there has been some more recent developments, but historically what we've seen in the industry rolled out is what was known as the Scorpion campaign, which was basically an attempt to educate the public, and indeed to a certain extent the pensions industry on the potential threat of scams. So you see now if a transfer pack goes to a member with their quote, there should be literature included within that pack, making them aware of potential scams and what they should be conscious of in terms of red flags. Red flags often be inappropriate investments which guarantee high returns, etc., which we'll cover on later in the presentation. It was later rebranded to Pension Scams in 2014. HMRC made steps to and took moves to strengthen their position. Historically, my understanding has always been that if you wanted to set up a pension scheme, in order to get the proper HMRC authorization, it was very much a request and process now and check later. The difficulty with that is that many of the scammers were able to get through this potential checkpoint with ease. And then I suppose once the transfers went into a scam arrangement, the prospect of someone looking at a scheme and saying this shouldn't have been set up isn't highly attractive. The checks need to be there in place before money starts entering into these arrangements. There's also the fit and proper test for scheme administrators from HMRC as well in September 2014, and perhaps arguably very importantly, the Pensions Liberation Industry Group, which has been set up to, I suppose, to collate views from within the industry on how we can tackle this subject and to give guidance. And that has been a big driving force, I believe, in trying to push the industry towards a higher standard. Next slide, please. Yeah, responsibilities for trustees, a little bit difficult, and there has been a recent, well, there's potentially developments on the horizon for this, but currently as it stands, as many of the people on this seminar will know, members have a statutory right to a transfer. But if you are a trustee or a scheme administrator and you are checking a transfer request and you have concerns surrounding the proposed transfer, what do you do? Arguably, you could proceed and pay the transfer. Doing so, is that in breach of your fiduciary duty to the member, knowing that you're willingly transferring their funds over to an arrangement which might cause them financial loss? If you perhaps decide that you won't pay the transfer because you don't believe it's morally correct and you're actually trying to act in the member's best interests and protect themselves, you're arguably then in breach of legislation which very clearly sets out that a member has a statutory right to a transfer. So for many trustees, I think where the decision ultimately lies, you find yourself trapped between a rock and a hard place, and it's very difficult to, I suppose, to balance up what you should do. If you go on to the next slide, please, Kaz. Yep, I think I've covered that. The next one, please. Yeah, so what would you do? So more recently, I've had some transfer requests as well, which I felt have been a bit suspicious on schemes to which Dalriada act as trustee. There are some very basic checks, which I guess most of us should be aware of, is to check that the scheme is fully registered with HMRC, which in my experience, they tend to be. Checking the sponsoring employer is a new company, or if it is indeed dormant. What we found in the past is that many arrangements have been set up. Companies have been set up as the sponsoring employer, but you will basically find minimal filing on company's house, and there's actually no evidence to suggest that the employer is actually genuine or providing any type of service or employment. If you speak to members, and that's probably one of the key points, is to always speak to the member regarding their proposed transfer. Many times members will be more than thankful for having any red flags raised with them, and to, I suppose, to be made aware that you're actually completing some checks on their behalf. But what we have found from speaking to members in the past is that during the conversation, which on the telephone is something they don't like to put in writing, that perhaps they've been offered cash before the age of 55. They've perhaps been promised an incentive, perhaps from an introducer. There are certain red flags which we often see, such as introducers essentially people who are paid to promote the pension scheme and to promote transfers into a pension scheme, arriving at people's houses with a photocopier in the back of a van. They will get the documentation signed and photocopied and disappear. Your pension's transferred into this questionable scheme thereafter. So it's really about speaking to that member, understanding why they want to make a transfer, how they've come to this point, i.e. how they were contacted, what advice they've taken, etc. And understanding what it is exactly they're trying to achieve. Now, this doesn't have to be the prospect of the big bad trustee ringing and questioning why you would possibly want to remove your funds from a certain arrangement. It's not about that whatsoever. It's about making sure that the proper checks are completed to ensure that when a member does transfer, he gets fair value for his transfer, and where his funds are being transferred to, they are safe and will continue to provide him with him or his or her security in retirement. Next slide, please. Yeah, so further a little bit more on responsibilities of trustees. And one of the key things I've always found with trustees is that they sometimes be at the end of the chain, and it's always very important to speak to the scheme administrator, who is the individual who actually deals with the member. And as they say, the key here is communicating with the member and trying to understand what has taken place to date. There is guidance from the Pensions Liberation Industry Group, which sets out all the checks in detail, which a scheme administrator and trustees should do collectively to ensure that they take all the right steps. You want to make sure that the members got all of the right literature. You want to double check that they have received advice where needed. If they have received advice, to double check the advisor on the FCA website, etc., and to check for any bad press, etc., which you can often find just by Googling individuals involved with pension arrangements. Should it be that a member is adamant that they wish to complete their transfer, albeit you as a trustee still hold reservations, one of the things that you may want to do is to ensure that the discharge forms are legally adequate to protect yourself as a transferring trustee and the scheme. Should a transfer be deemed, I guess, unauthorised in due course, that would lead to tax consequences to the scheme, namely a scheme sanction charge as well, which, if that is paid out of the scheme which you're a trustee of, that would be to the detriment of the members which have remained in the scheme. So there's quite a lot to do here in terms of making sure that you follow the process. The key, besides speaking to the administrator, is always to document what you're doing, is to have the checklists, is to have the correspondence with the member, the telephone notes, the letters, and to document that you've taken all of these steps, which one would deem appropriate for a trustee and a scheme administrator to take on behalf of the scheme. If in doubt, you may wish to take legal advice. Now, in the past, I've sought legal advice on one specific case regarding a transfer. The member was very adamant that he would transfer out of the scheme. We had, I suppose, strong concerns regarding the people behind the proposed arrangement and how that scheme was going to operate. So we sought legal advice. Now, important to remember that every scheme and set of trustees should seek their own legal advice as opposed to relying on any other advice provided to any other party. But the advice we had was that the statutory right to a transfer essentially overrode the trustee's fiduciary duty to the members, and that if the member was adamant that he wished to proceed with the transfer, that we should then process the transfer, albeit set out our reservations and ensure the discharge form was adequate. Luckily, on that particular case, the member changed his mind at the last moment, and we didn't have to make that transfer. And I'm still very confident to this day that the proposed arrangement which the member wished to transfer to was nothing short of a scam. Next slide, please, Cass. Yeah, what does all of this mean? As I've just covered off many of the things which a trustee and a scheme administrator should collectively do. All of this adds to time and cost. It can add to the time delay in actually being able to process any transfer request out, it can add to significant cost. In particular, if you have to start speaking to members more regularly, reviewing additional paperwork, and also seeking specific legal advice. But I think my view would be that the time and cost incurred is probably an appropriate thing to do to ensure that the right decision is made. As I've said before, this isn't a case of trustees trying to limit transfers out of pension schemes. It's simply a case of trustees trying to limit and stop transfers out of pension schemes to scam arrangements as opposed to legitimate arrangements. Arguably, where, you know, looking at things pragmatically, if you have a transfer request to likes of L&G or Prudential, you can be quite pragmatic in the amount of time which you will have to spend, you know, checking that transfer. But should you receive one from a pension scheme which has just been set up 12 months ago with an employer which has no filings, then arguably you should be spending a bit more time. Next slide, please. Yeah, Dalriada experience. This is, I suspect, a little bit outdated in terms of the figures I have in here. So my understanding, as I say, is Dalriada has been working on these schemes since around 2011. The first schemes which came to Dalriada were what was known as the ARC schemes, and it was basically a reciprocal model where the perpetrator set up 6 different schemes. And in the simplest terms, the way of explaining this is, if you have scheme A and scheme B, what the people would do to, I guess, try to circumvent the tax rules is that a member of scheme A would make a loan to a member of scheme B and vice versa. So arguably, the member was not taking receipt of their own money before the age of 55. They were taking a loan from a different member of a different pension scheme. And therefore, the view was that perhaps may not have been pensions liberation. That point has been tested through the courts. The Bean judgment, as it's known, found fraud on the power of investment, so the loans to members were void, and now have given rise to unauthorised payments to members. Those unauthorised payments, which is essentially the tax charge for making the inappropriate payment, is then followed up by what's known as a scheme sanction charge, and the scheme sanction charge is levied against the assets of the scheme. So besides the members being taxed on particular ARC cases, the ARC schemes, which Dalriada are now trustee of, have received tax demands in the form of scheme sanction charges. So you're essentially taxed at 2 levels. More generally at Dalriada, the membership of the schemes which we look after, which we would attribute to sort of the scam side of the industry, probably around 6,000 members or so on our database. Funds transferred in now probably amount to around 270 million. So as I said, this is quite a big problem, and how many cases have actually been uncovered and how their proportion of the actual cases which have taken place remains highly questionable. So it may very well be that there's a lot more scam cases out there, and unfortunately for those schemes, they wouldn't have had a professional pension trustee appointed, so there would be very little hope for members, I suspect, in those cases. Next slide, please. Yeah, so what we found historically is that the original arrangements would have had, I suppose, a very crude attempt to work their way around pensions legislation and tax law. In more recent years, what we've seen is just a move towards questionable investments, as I guess that the perpetrators got greedier and realised that they didn't have to actually offer as much cash back out to members. A lot of this, again, refers back to the fact that there is, I suppose, a lack of financial education, arguably, within our public, which is something which we as the pensions industry and probably the wider financial industry have to continue to address. But some of the more questionable investments we have seen in recent years have been timeshares in St Lucia, a car park in North London, a learning application for mobile devices, which didn't actually do very much, a theatre production of Coronation Street, which went on for one night and never made it to the stage on the second, and a gentleman's club in Derby. So luckily on that particular one, the pension scheme did not run the club, they owned the property, and that property was able to be sold at a later date, which actually returned some funds to the scheme. But that shows you, I suppose, the diverse nature of the investments or purported investments which the perpetrators have used. You will note that none of these investments are regulated. There will be issues with liquidity, and when the regulator says go for diversification, this is not exactly what it meant, I suspect. One of the more recent cases is worth touching on very briefly, is the case of Norton Motorcycles. Some people may have picked up on this in the pensions press, but also the more general press. So Dalriada was appointed as a trustee to 3 schemes with links to Norton Motorcycles. So for those who don't know, Norton is quite a historic British brand in the motorcycle industry. It has a racing heritage, and Norton in recent years has seen a bit of a revival with a new factory and new models being rolled out. And the bikes look fantastic, and it has some very high level endorsements, including from politicians and celebrities and the likes. And the business looked, on the face of it, like it was a real, I guess, goer with real potential. Now, what has actually come to light since Dalriada's appointment, and this has been freely reported in the press, that much of Norton Motorcycles and its recent revival was actually based on 3 pension schemes which were deliberately set up to fund the business. Those pension schemes received transfers in excess of around £10 million. That £10 million was then used to fund the business, but this, arguably brings to the forefront many issues, such as if all the pensioners' funds, if all the pension scheme funds were invested in one particular business, there's very little liquidity, diversification, and again, we're not meeting the threshold for investing in regulated markets. Norton Motorcycles then has went into financial trouble in recent times, and it remains very unclear what exactly will be returned to the pension scheme. So again, this highlights the risk of some potential transfers. So for this particular case, many members of the public were enticed into transferring into these schemes on the basis that they knew the Norton brand, which, as I say, is highly known in particular in the motorcycle industry, and people thought it was reputable. But behind it was a link between a business and 3 pension schemes, which should never really have happened. Next slide, please. Yeah, I guess where are we with HMRC and taxation, which is something I've briefly touched on, and I'll hurry up a little bit because I fear I may be running out of time. HMRC's view at a very high level is that pensions liberation is essentially tax avoidance. And where they can, they will levy unauthorised payment charges against the members. The difficulty is in the early days, there would have been some documentation and or structure to the loans or payments given to members. In more recent years, what you will have seen is that members would have received payments from unknown foreign entities, such as a random bank account in Dubai, which was essentially used to channel money back to members. How HMRC will get to the bottom of who got what remains to be seen, and I think that's going to present a big problem for them. It may be that they do a blanket approach across members in terms of taxation and let members prove that they received otherwise. Next slide, please. Yeah, where are we now with I suppose steps to protect the industry, and I can move on a little bit now more to some of the more recent developments. As I say, HMRC have moved away from the process now and check later. We have the fit and proper test. What we do have now is in recent days TPR scams pledge, which is essentially the TPR is asking pension providers, administrators and trustees to sign up to a pledge to have a higher level of due diligence, to complete certain checks, and to ensure that there's proper safeguards in place for transfers. We also have, I believe, a new section on the trustee toolkit specifically in relation to pension scams. So for any trustees on the call, that is something which we should be going ahead and doing right away, and indeed also for administrators and most people involved in the pensions industry, I would suspect. There has also been some recent developments in the what's known as the Fraud Compensation Fund, which is managed by the PPF. Now, the Fraud Compensation Fund was set up many years ago to compensate schemes where there has been a level of fraud or dishonesty. And historically, I don't believe there has been really many applications to that compensation arrangement. However, there has been a test case, I guess, recently in terms of pensions liberation schemes and to what extent they could avail of the Fraud Compensation Fund. So a few of the barriers would be it has to be an occupational pension scheme, there has to be a particular insolvency event of the linked employer, etc. But what we have had in recent days is court direction in relation to the Fraud Compensation Fund, and essentially it sets out that in principle schemes which have been targeted or I suppose a victim of pensions liberation or scams are in principle eligible to make applications. Now, how all of this will work out in terms of the technicalities of how much compensation and how it's awarded towards costs and different things still has to work out, but it has been a positive development which will allow potentially many schemes which have fallen victim to scams to make a claim for compensation. How exactly the FCF, Fraud Compensation Fund, will be able to fund all of this, considering the high volume of transfers into these schemes, is also something which I believe will have to be figured out in due course. Next slide, please. Yeah, what trustees should be aware of, I think we've sort of covered this off. It's basically about talking to your administrator. It's about making sure that the right paper trail is in place. It's about taking legal advice should you need to do so. It's about educating both, our own colleagues and ourselves, but also the members of our pension schemes regarding the actual risks out there. And also, I believe that there is most likely to be some development in due course regarding the statutory right to a transfer point. So as I say, as it stands, a member under most circumstances has a statutory right to a transfer, albeit they wouldn't have if they were too close to their NRD. But there will be, my understanding is there will likely be changes which could potentially allow trustees to have some discretion surrounding the statutory transfer point if indeed there's certain thresholds met, such as red flags regarding a possible transfer. Now, this is something which would give trustees the ability perhaps to refuse to make a transfer on very unique grounds. And as you say, this isn't something which is designed to stop people from transferring. It's to target the small amount of cases where members would potentially transfer to a scam arrangement. Next slide, please. And thankfully that is me done for everyone who has now had their fill of pension scams at 10:30 in the morning. I'll still be here at the end for questions, but I'll now hand over to Justin and Paul at Weber Lake Bell for equalisation. Thanks.
Thanks, Martin. So, hi, I'm Paul Ashcroft. I'm a pension solicitor at Wedlake Bowl. Joining me today is Justin McGilloway, who is a partner in our pensions team at Wedlake Bowl. Today, we're going to be talking about equalisation issues that continue to be problematic for many schemes that we've come across. So, for example, we found that equalisation issues can still come up when trustees review their scheme's governing provisions or when scheme rules are scrutinised as part of a buyout with an insurer. If anyone has any questions, we'd be happy to pick these up at the end. Next slide, please, Caroline. Thank you. But before going on to look at some worked examples of common equalisation issues, let's remind ourselves of the background to equalisation law generally. Equalisation law stems from the principle of equal pay under EU law under Article 157 of the aptly named Treaty on the Functioning of the European Union, which does exactly what it says on the tin. This was formerly Article 119 of the Treaty of Rome, and this states that each member state shall ensure that the principle of equal pay for male and female workers for equal work or work of equal value is applied. Next slide, please. In the past, many schemes had different pension benefits for men and women, and this was common practice at the time. The Court of Justice of the European Union then clarified in Barber that the principle of equal pay between men and women also applies to occupational pension schemes. Following Barber, pension schemes were required to equalise men and women's normal retirement dates in relation to benefits from the date of the judgment, in other words, from the 17th of May 1990 onwards. However, for some time after Barber, it remained unclear how this was to be achieved, with various cases seeking to clarify the position. Justin, did you have anything you wanted to add on Barber?
Yeah, well, we're rewinding 30 years here to 1990. I get quite nostalgic when I think about 1990 because I remember what I was doing, and it was not as a pensions lawyer. But if you set the scene, George Bush Sr. was the president in the US, Margaret Thatcher was in Downing Street, and Pope John Paul was in the Vatican. And my colleague Paul, who now practices in pensions, wasn't even born yet. But the Barber case was an actual action against the employer. It wasn't against the trustees of the pension scheme. And just to put some meat on the bones, Mr. Barber was made redundant at the age of 52 and received various cash benefits as a result of that, but he was not entitled to take his pension, and that was the key difference between what a woman of the same age was allowed to do, because she was entitled to an immediate retirement pension in addition to any redundancy or cash benefits. Now, Mr. Barber took this all the way to the Court of Justice of the European Union, that pension should be treated as pay under Article 157, the treaty that Paul mentioned, and that as a consequence he should therefore be entitled to the same benefits as a woman of the same age. Now, the key thing here was that the court's decision at the time was not retrospective, so it takes effect from the 17th of May 1990, the date of the judgment, and that's a key date that we'll mention going forward. But it's only in respect of the entitlement to benefits accrued in relation to service from the date of that judgment. So next slide and back to Paul.
Thanks, Justin. Yeah, so one of the cases that we'll look at first is Ten-Over, which was a Dutch case that confirmed that a survivor's pension falls within the scope of Article 157. And as a result, any circumstances in which a scheme benefit is payable to a widow must also be payable in the case of a widower. Next slide, please. Then we'll take a look at Collerall and Smith v Abdul, which were two judgments that were both handed down on the 28th of September 1994. In these cases, it was clarified that where a scheme is less favourable to one sex, the scheme must be modified in accordance with its amendment power to level up benefits to those enjoyed by the most favourable sex. And this must be done from the date of the Barber judgment, like Justin mentioned earlier, which is 17th of May 1990, up to the date that the scheme is amended to equalise benefits. And this period, from the 17th of May 1990 up to the date that benefits are amended, is often referred to as the Barber window.
Now, the equalisation in pensions is one of those areas where throughout history there's really been no clear policy or decision of principle underlying the development of UK law in this area. For many years, it was thought that the implementation of sex inequality in pension schemes was actually not practicable because pension schemes, by their very nature, are discriminatory on a number of grounds. The cost issue alone was a sufficient deterrent to prohibit equalisation. And pension matters were expressly excluded from equal pay and sex discrimination legislation passed in the 1970s and 80s. So the law in this area has really grown in fits and starts, and very much of it is a reaction to developments in EU law, as we can see from a lot of these cases. However, I'm pleased to say it's probably an area of the law which most major issues have now been resolved, although there are a few anomalies that still remain, most notably GMP equalisation, which I won't steal Carl's thunder on because he will present on this later, but to my mind it is the last piece of the pension equality jigsaw. But for decades, equalisation, certainly in the industry, has been seen as the gift that keeps on giving, and we can certainly see that with GMPs and the attempts to get our heads around that. Next slide, please. Now, the next important case is actually a UK case in this area, and we fast forward to 2009, So we've got Gordon Brown in Downing Street, George Bush Jr. in the White House, and Pope Benedict in the Vatican. But the case I want to talk about is Foster Wheeler. Now, Foster Wheeler versus Hanley and others, it's a fairly typical case. The scheme rules, so prior to May 1990, female members of the scheme had an NRD of age 60, and male members had an NRD of 65. Now, from May 1990 to August 93, all members accrued benefits based on an NRD of 60. So this is this concept of a Barber window that Paul mentioned. So the benefits are leveled up, confusingly leveled up shoes, but the NRD for men and women is determined at age 60. So in order to create this Barber window, the scheme rules were amended from the 16th of August 1993. So thereafter, all members were given an NRD of 65. Now, in looking at this, where you've got mixed NRDs for members, the High Court held that the High Court, in this particular case, that all members could receive their benefits as a single pension from age 60 with no early payment reduction applied to the tranche of benefit accrued with an NRD of 65. Now, this was happy days for anybody who had benefits accrued by reference to age 65, because those members were now in line to receive a significant windfall. Now, significant windfalls in pension schemes ultimately have to be funded by the employer, and the employer, not being very happy with this decision, decided to take it to the Court of Appeal. And the Court of Appeal were asked to look at 3 different options, 3 different mechanisms in a way in which this could be interpreted. One, stick with the decision of the High Court so that everybody gets this, well, people get this windfall. 2, a single pension with benefits accrued with an NRD of 65 actually reduced, or getting more complicated, you split the pension so that benefits are payable from different NRDs. And this was actually a decision of the Court of Appeal in an earlier case called Cripps and Trustee Solutions. Now, the Court of Appeal saw sense, I'm glad to say, and actually settled on option 2. They determined that that was the correct approach, that being that a single pension was payable with the accrued NRD 65 element reduced for early payment. So everybody receives a single pension payable from 60 with elements reduced. Now, the facts of this case were very specific, and the outcome here may not be the same for all schemes, and that's why legal advice is obviously important, but more importantly, it's the facts of the case which can guide and distinguish the actual outcome. But the Court of Appeal did set some important guiding principles for us lawyers. If we could move to the next slide, please, Caroline. Oh, sorry, back. Getting ahead of myself. The principles are basically, where possible, effect should be given to Barber rights by adhering to the scheme provisions. Now, of course, that's not always possible because the scheme provisions may not be up to date or actually have taken into account equalisation. The next principle being, so if there is some departure from the scheme provisions, if that is required, then the amendments should represent the minimum interference to the actual scheme provisions. This concept of minimum interference can be quite difficult, especially if you've got rules which just do not work. So we'll come and look at some specific examples of how we can actually equalise benefits later on in the presentation. The other couple of principles deal with the options that one looks at should be compared, and in terms of the actual cost and proportionality of equalising benefits. So I'm glad to say that the courts are actually taking that into consideration, but ultimately it's doing what's appropriate and right for the scheme in question. Next slide, please.
Yeah, thanks, Justin. And I think, like Justin said, it's something that we do see come up time and time again. So we'll consider it again, this issue of minimum interference in some of the works examples a bit later on. But currently, the general sex equality rule in occupational pension schemes is implemented under UK legislation by Section 67 of the Equality Act 2010. And Section 67 is really important because, firstly, it implies into scheme rules that if an occupational pension scheme does not include a sex equality rule, then it's to be treated as including one. And secondly, it also provides that a sex equality rule is a provision that is modified so it's no less favourable to one sex, not only in circumstances where a relevant term treats one sex less favourably than the other, but also where relevant discretion is capable of being exercised in a way which would treat one sex less favourably. Next slide, please.
Yeah, and as I said, this area of the law is developed in fits and starts. It's been a real hodgepodge of case law, but the Equality Act is an attempt on the UK legislation to bring together in one place all things discrimination in order to ensure equality across the board. Now, these two pieces of legislation that we state here, Section 62 and Section 68 of the legislation, are very handy pieces of legislation for trustees, because what they do is it gives the trustees an overriding power under Section 62 to make alterations to scheme rules to actually prevent discrimination, and under Section 68 to make alterations to give effect to sex equality. Now, the reason why these are handy pieces of legislation is that they can actually circumnavigate any complex or demanding amendment powers contained within the rules. So that the legislation itself talks about where scheme rules are liable to be unduly complex or protracted, or involves consents which cannot be obtained, or which can only be obtained with undue delay or influence. So this is allowing trustees a fast track approach in order to bring their schemes up to date as far as equality is concerned. Next slide, please.
Yeah, so I think Justin would agree that if there's anything to take away from today's session, this is the slide to really take away. Because if we were to summarise where we've got to as a result of Barbara and the subsequent cases, it's now established law that for the period before the 17th of May 1990, pension schemes are not required to equalise benefits. But for the period between the date of the Barbara judgment up to the date that the scheme is amended, pension schemes are required to equalise men and women's benefits so as to level up to those enjoyed by the most favourable sex, in other words, the Barbara window. And for the benefits after the date that the scheme is amended, benefits must be equal between men and women, but can either be levelled up or down. Next slide, please. So next, we're going to consider some common equalisation issues. Next slide, please. So the first issue that we're going to look at is what documents are used to equalise. So some of the first questions to consider are what document was used to equalise benefits in practice, and what documents can be used to make amendments under the scheme's amendment power. Next slide, please. And another common issue that is often linked with the first issue is where benefits have been equalised with retrospective effect from the date on which amendments were made. So therefore, when looking at equalisation issues, it's always important to ask, what is the date of the amendment deed, and when does the equalisation amendment say that it takes effect from? Another question to ask is one sex made worse off as a result of the retrospective amendment? So, for example, where a scheme has a normal retirement age of 60 for women, but retrospectively equalises to age 65. This is typically less favourable for women than had it continued to be age 60. And the case law has confirmed that it's only permissible for schemes to leave certain members worse off going forwards. At this stage, it's also important to check what the scheme's amendment power says. So although typically you would expect the amendment power to permit amendments that make benefits worse off going forwards. And then the final question to really think about is, do the retrospective adverse amendments also fall foul of Section 67 of the Pensions Act 1995? And often legal analysis will be needed to determine that question, including whether or not Section 67 was actually enforced at the time the amendment was made. Next slide, please. So yeah, these first two issues were considered in Safeway and Newton, which was referred back to the Court of Appeal earlier this year. In this case, the employer and the pension trustee informed the members by way of an announcement made in 1991 that the scheme would be amended to equalise with effect from the 1st of December 1991. Then, several years later, on the 2nd of May 1996, a trust deed purported to amend the scheme to equalise benefits with retrospective effect to the announcement made in 1991. The Court of Appeal was satisfied that amendments made under the scheme's amendment power had to be made by a deed and not by an announcement. But unusually in this case, both 1, the scheme rules, and 2, UK legislation in force at the time, both permitted retrospective adverse amendments. And this is because the events preceded Section 67 of the Pensions Act, and which would have protected against retrospective adverse amendments. However, the Court of Appeal was not certain whether the ability to equalise retrospectively was permitted under EU law, and so the case got referred all the way up to the CJEU. In October 2019, the CJEU held that, in the absence of an objective justification at least, that the pension scheme is precluded from adopting a measure to equalise benefits retrospectively between the announcement of that measure and its actual adoption, even where the scheme rules and domestic legislation permit it. And therefore, the amendment purporting to equalise the scheme rules did not have retrospective effect back to the 1st of December 1991. But like I said, this was an unusual case in which the amendment power permitted retrospective adverse amendments. Most of the time this won't be the case, particularly where Section 67 applies or there's a prohibition in the scheme rules. Nonetheless, Safeway is an important reminder to check a scheme's amendment power and not assume that an amending document is validly effective. Next slide, please. Justin, did you want to consider this issue?
Yeah, sure. So again, we've seen all sorts of ways and methods of equalising schemes as between male and female NRDs. The most common that we see is simply amending the NRD. So previously, where you have a scheme that had a normal retirement date of 60 for women and 65 for men, the scheme is simply amended to have an NRD of 65 for both men and women going forwards. But in this particular example, we had buried within the guts of the rules was another way of doing it, where it had this concept of special service. Now, I'm conscious of time and I don't want to go into it in too much detail, but it's just really to give you an example of other ways of equalising benefits that perhaps aren't as obvious to the untrained eye. Next slide, please. What we had here was the actual definition of special service was for a male member, any pensionable service completed between 17th of May and the 31st of November 1996. So straight away you can see that's your Barber window. That's the attempt to equalise benefits between that period, and then from the 1st of December onwards, 1996, the normal retirement dates have been equalised. Next slide, please. Again, just harking back to the explanation I gave of Foster Wheeler and the 4 guiding principles laid out by the Court of Appeal in that decision. These are the key questions that really one needs to look at when you're attempting to get to the bottom of whether a scheme has equalised. You may be surprised to hear that not all schemes have done this properly, and when we take on a new scheme, we undertake a health check of the scheme. It's more than kicking the tires. I sometimes call it an MOT, but it's really getting under the bonnet of a scheme, and more often than not, any issues that do pop up tend to pop up as far as equalisation is concerned. Next slide, please. This this final sort of stretch that we're on now, coming to a close, is an example of where a scheme has really messed up. And again, this is a real life example. I believe it was a DIY attempt at equalising benefits. A lot involved, not a pensions lawyer, but with what this slide shows is an example of the definition of normal retirement date, and it's attempted to equalise benefits. and the story goes that on the 1st of June 1992, an announcement was issued to the members, and the scheme rules were updated in an attempt to equalise the benefits from the date of that announcement. But it was a real car crash, because what they've inadvertently done here is, in an attempt to equalise, basically given men, you can see under 2A, given men at age 60 NRD going forward, which of course is disastrous as far as any attempt. Now, we did dig into this scheme hoping that there was some other clever way of closing down the Barber window and actually addressing the mistake that was made here, but alas, no. And so the situation we had was, for a period of 20 years plus, males were given this NRD of age 60, and it put a hell of a funding strain on the scheme. So again, another example, huge red flag on this particular example, and something that legal advice, of course, is necessary in this area. But without further ado, we'll pass to the next slide, which I think is wrapping things up. Paul will say a few words.
Yeah, so that's perfect. Well, thank you very much for listening. Please let Justin or me know if anybody has any questions.
Yeah, just on that, first of all, thank you, Justin and Paul. And just before we hand over to Carol, just a reminder to use the Q&A box and to take this opportunity of getting anything clarified or any questions answered. As I say, I'll keep an eye out and we'll catch up with the questions at the end. Carol, over to you.
Thanks, John. Thanks, Paul and Justin, for your presentation. I'm going to talk about GMP equalisation. Just a little background in relation to myself first. I've got 30 years experience in the pensions industry, mainly in administration and some consultancy background as well. Joined Del Riada in July last year, and now working on the trustee side. So that's just a little bit about myself. So today we're going to talk about GMP equalisation, and the things we're going to cover are GMPs and the requirement to equalise. We're not actually equalising GMPs, what methods are available, what needs to start now, issues still to be resolved, data audit and ongoing administration. Next slide, please, Kaz. So this is just a little bit of background in relation to equalisation. I won't go into much detail in relation to this, as we've already had a presentation in relation to that. But before April 1997, contracted out pension schemes had to provide at least a benefit equal to GMP, and this was deducted from the state benefit the members accrued. Most schemes provided a benefit in excess of GMP. The GMP for males and females accrued at a different rate, which meant that for a female and a male with identical working history, the GMP for the female will be greater than that for a male. And then on the 17th of May 1990, as previously explained, we had the Barber judgment, which meant that benefits had to be equalised for males and females. This, however, was just in relation to benefits in excess of GMP. Prior to this date, you normally had retirement ages of different for males and females. So female would have an NRA of 60, and males would be 65 generally. However, the court, European Court, decided that that was not possible any longer. Next slide, please, Kaz. So if we fast forward to 2018, the Lloyd's judgment, that there was the judgment there was a requirement to equalise GMPs, and in effect, trustees have a duty to amend scheme benefits so that both males and females had the same benefit in respect of their GMPs. Next slide, please, Kaz. So, as I said, we're not actually equalising GMPs. GMPs are determined by legislation, and this isn't changing. What we effectively have to do is to provide an equal pension for members' benefits in relation to the unequalised GMP, so effectively giving them an uplift in the benefits. It's normally referred to as GMP equalisation. As I've already said, we're not actually equalising the GMP, so this is slightly misleading in that respect. So what we're effectively saying is that if a member would have been better off being treated as the opposite sex in relation to GMP between 1990 and 97, then we need to do something about this, and the benefits need to be equalised for that period. There are, however, more than one method to achieve this. I'll go on to look at those next. So next slide, please, Kaz. So there are effectively four methods. Method A is to equalise each unequal aspect. So in effect, you'd look at a male and female with the same employment history, and you would provide, if the female had a higher GMP, then the male will be provided with that benefit, and the male would have a higher excess benefit and the female would get that. So in effect, you would be increasing the pension for all members. Methods B and C, they both provide, they look at the benefit on a year by year basis and pay the maximum that would have been paid to either sex, although they are slightly different in their approach. And then method D is an actuarial equivalent of benefits, and D2 would be a conversion as well, so you would no longer have any GMP benefits and all benefits would be classed as excess. There are more upfront costs in relation to D. However, going forward, the administration of that would be much simpler. But there will be pension tax issues in relation to converting benefits. So next slide, please, Kaz. So in the Lloyd's judgment, the only methods that were viable were C1, C2, and D2. But other methods, as explained previously, there are other methods available, and schemes should take legal advice before deciding which option to go down. D1 is only deemed suitable if the scheme is in wind up. We expect the majority, although I've said you need to take legal advice, would expect most schemes to adopt C2 for ongoing administration. This is the least costly option up front, however, will be more expensive going forward because you would have to have dual records, and I'll come to that in a little bit, or the conversion to go to D2, which would be more upfront costs, but would be cheaper going forward. We also need to consider looking at the payments already made to members, which have been unequal. You can't use D2 in that respect because this would be using an actuarial assumptions. So you would need to look at a comparable method each year. So something like C2 would be most appropriate for looking at back payments. As at the bottom, you don't need to use the same method for all groups of members, but I would suspect that if you decided on one option, that would be applicable to all members in the scheme. Next slide, please, Kaz. So if we look at the comparison of the methods. So method A, as I've said, that would provide the highest level of pension for all members. This would be an initial adjustment, and then you would have benefits going forward, and in effect, all members win in that respect. So method B, you would need to have dual records in relation to each member, and the members would flip between the which would provide the higher benefit whilst in retirement. There are no winners in that situation, but members get the benefit that they would be entitled to following the Lloyd's judgment. Method C, again, is similar to method B in that you have dual records, and members would get the benefit they were entitled to, and it would flip between the two depending on how benefits had increased. And again, there'd be no winners in that, but they would get the benefits which they were entitled. And then method D, this is where the actuary makes assumptions, and in this case you would have winners and losers. It depends on specific individual circumstances. So we'll probably, for most schemes, look at considering C2 as that is probably the most the option where people have the benefit that they should be entitled to, and there are no winners or losers in that respect. So next slide, please, Kaz. So what needs to start now? First of all, you need to consider the method that the scheme wants to look at. This is a trustee responsibility, and you would need to take legal, like I said, you'd need to take legal advice in relation to what method would be appropriate for your scheme. You also need to look at the data that each pension scheme has. So GMP reconciliation, which has been going on for quite some time now, if that hasn't been completed, that needs to be finished off. And also you need to audit your data, need to make sure that you have sufficient information in order to make the calculations necessary. As I said, you need to sign off from your legal advisors, and as in the previous presentation, you need no ambiguity in relation to the Barbour window, which, as we will all have experienced, there are cases where the Barbour window is not as expected, and there were examples in the previous presentation in relation to that. Next slide, please, Kaz. So there are still issues to resolve. There are tax implications, and we're awaiting guidance from HMRC in relation to that. Past transfer values. So in effect, past transfers have been paid out on unequalised benefits, and the discussion as to whether these need to be reconsidered in light of the Lloyd's judgment. It's expected that past transfer values will need to be reconsidered, but we're waiting judgment in relation to that. So the other thing that people have been discussing is de minimis cases. So would expect, however, that most schemes wouldn't adopt this and provide the same level of benefit for all members. In order to determine whether you've got a de minimis tolerance case, you'd have to have calculated the benefits anyway, so you might as well pay them the benefit that they're entitled to. Next slide, please, Kaz. So as I've said, you need, in relation to your data audit, you need to ensure that you've got the data required to carry out the calculations. Consider any gaps in the data, and look at your scheme history, and collate information in relation to any scheme quirks in relation to members. There's also issues in relation to members who are at or above the lifetime allowance or have protection. If you increase their benefits, they could potentially lose the protection, and there could be tax implications in relation to that. So next slide, please, Kaz. So for ongoing administration, you've got transfer values and trivial commutations. To date, these have been quoted on an unequal basis. However, I would stress that trustees need to look at this, and if they're still providing unequal or transfer values on an unequal basis, they need to consider this and should consider what option is available and to start providing transfer values that are on an equalised basis. So if they've quoted on an unequalised basis, they should, however, be settled by a manual adjustment to uplift the benefits so that they are on an equalised basis. This would require actuarial input and would be based on the actuarial assumptions. In relation to in-scheme benefits, so example retirement, you would still expect these to be settled on an unequalised basis, and therefore members would get what they would have been entitled to prior to the Lloyd's judgment. And these would be dealt as part of the main project to uplift benefits so that they provide equalised benefits. Next slide, please, Kaz. So that was quite a whistle-stop tour. So any questions would be welcome.
Thanks very much for that, Carol. I have been checking the Q&A box. Nothing has been posted yet. I think it's just a reflection of all presentations. We're very, very clear and comprehensive, but there is still time for people to ask a question if there is an issue that they would like to have clarified or resolved. In the meantime, I'll maybe exercise Chair's prerogative and ask the first question, or maybe an observation first, then a question. Carol alluded in his presentation to further judicial guidance on past transfers and who might be liable for past transfers that were not equalised for the effects of GMP. Rumour has it, but it's nothing official, that the judgment on past transfers will be out on Friday. So something to look forward to and something to read over the weekend, of course. But maybe turning to more immediate matters, if I could address a question to Paul and Justin. I mean, as you alluded to in your presentation, equalisation now been going on for 30 years, since May 1990 and Barber, and it does seem to be the gift that keeps on giving. But I think many people thought that with the Lloyds Bank Group ruling in October 2018 telling us that we had to equalise for the effects of GMPs, that was maybe the last piece of the jigsaw in terms of substantive matters, and probably other litigation in relation to equalisation would be quite scheme specific, and maybe Safeway as an example of that. But I just wonder, is that a statement that you agree with, or within the pensions legal profession, is it still felt that there maybe are one or two things that are still in Pandora's box?
Well, it's a very good question, John. And in terms of GMP equalisation, the first noises were made about equalising GMPs in 2010, I recall, by a Labour government. And if we fast forward a decade later, we're closer to knowing what schemes are required to do. But of course, and I have a subsequent question for Carl in a second, but the schemes that I'm advising on, of course, we've been talking about GMP equalisation now since the Lloyd Bank judgment, but of the dozen or so schemes that I'm responsible for to provide legal advice, only one of them is actually pressing the button and actively seeking now to equalize benefits, because and I think that's because there's so many unanswered questions, whether it's the past transfers, which, as you say, hopefully we'll get some guidance on that this week, the treatment from an HMRC perspective and the interaction with lifetime allowance, annual allowance, etc., etc. But I think it's inevitable that equalization hopefully should pick up some steam over the next 18 to 24 months. But again, inevitably, I think there will be litigation coming out of it, of the methodologies in terms of schemes perhaps deciding not to do it. Carl touched upon the de minimis rule, and then of course it's locating and paying out, and people who have transferred out, divorce cases. You know, the list goes on and on in terms of potential problems. And of course, as a lawyer, of course, I would say that, but I don't think we've heard the end of it in terms of other issues, especially stemming from GMP equalisation.
Yeah, indeed, lots more to look forward to then. I mean, just on that, I mean, I think, you know, our experience is the same as yours, and please, any of the attendees, if you think differently, but please say so. But, you know, our view as a firm is that schemes should now be getting on with addressing GMP inequalities. It's quite remarkable, isn't it, that we're already 2 years past, you know, the substantive judgment in the Lloyd's proceedings, and I do quite often say, you know, at what point could do you think a member might successfully bring a complaint of maladministration for not having his benefits equalised for GMPs? You know, given that's as I say now, over 24 months.
Well, that's right, and again, a lot of schemes are making provision in their triennial valuations. A lot of administrators and actuaries are making noises that the liabilities, you know, on a granular level per member aren't very much. But at the end of the day, from a trustee point of view, whether they're very much or not, that's money that's due to members, you know, historically or otherwise. And yeah, there does seem to be a reluctance. Everybody seems to be waiting for one person to make the move, but we've got enough now, I think, to start getting on with it. Hopefully, you know, with the reconciliation and getting your data in order, I think now is the time to pick up the chalice and just crack on and see where we get to.
Yeah, I mean, I don't think you would have any dissenters on this call. I mean, drilling down, I suppose, the getting on with it. I mean, back in October 2018, I think everybody kind of saw conversion as a bit of a panacea. Not only could you address your GMP equalisation duties, but you could get rid of GMPs and, you know, forget about things like anti-franking, which of course is even older than pensions equalisation. But what we've kind of seen here, I think with our own schemes who are looking at it now, is maybe a move away from using D2 and using one of the year-on-year methods, and probably principally C2. And in fact, generally speaking, we are just a little bit worried about some of the challenges with conversion and the fact that some of them, maybe especially the tax challenges, we probably can't be properly and fully and safely addressed unless we get some amending legislation or at least some kind of interpretation from HMRC which provides reassurance. But where are you with your own clients on discussion of methods?
Yeah, no, I think originally the conversion seemed to be the panacea, as you quite rightly say, but most people are now turning towards the year-on-year methods for the reasons you've just mentioned.
Okay, I just do a final check of the Q&A box, and I don't see anything posted, so we'll give people an extra 10 minutes in the day. And just as I wind up, if I can say thank you to all our speakers today. to Martin, to Carol, and a special thank you to you, Justin, and to Paul for joining us. Thank you everyone for attending, and our marketing function will send out details of the next Future Influencer webinar, I'm sure fairly shortly, and hope to see you then. Thanks everyone, and stay safe.
Thank you very much, everybody. Take care.